Thanks very much for having me here. I'm really pleased to be here, and thanks in particular to Min-Shin for laying the groundwork so well, because actually that's going to save me a lot of time, but I won't have to explain certain things I thought I might have to explain. I'm going to talk about the legal issues in the fourth plenum. The whole fourth plenum was about legal issues, as we know, and there's just a sort of a particular few I'm going to pick out, give you some big picture ideas, talk about some major changes, talk about some minor changes, and then talk about some things that didn't happen. What's the big picture? I think the big picture is that in the rule of law, no fundamental reforms contemplated in the relationship between the legal system and the party. It's clear that institutionally speaking, the party is going to remain above the law. We're not talking about a move towards what we could call rule of law. But, what about rule by law? So, in other words, a system of largely predictable and kind of rule-governed behavior by lower-level governments, even if those giving the orders are not ultimately accountable or constrained. And I think here the decision does contemplate some genuinely meaningful and, in my opinion, positive reforms. And there's also a number of things that might look meaningful, but as I shall explain, maybe aren't that meaningful. As Min-Shin explained, so I don't need to go into detail, all throughout the document, the decision of the fourth plenum, we see party first, law second. So leadership of the party, we see that over and over again. We are told that judges should be loyal to these four things: party, state, people, law, listing the party first. And we even, after a certain period of disappearance, see the resurrection of this doctrine of the three supremes, who are not, the singing group from Detroit, but are the Sangha Zhishang. So legal system personnel should give highest priority to the cause of the party, the interests of the people, and then last, the Constitution and the law. And, it doesn't say that they have to be in that order, but they are in that order, and it's not, these documents are not formulated randomly. These documents are formulated with intense attention to every single comma, and so this order is not accidental. Looking at the meaningful reforms, I think the decision calls for significant reforms in the system for managing judges. As Min-Shin talks about, it proposes to establish kind of essentially a career civil service model for the judiciary. Junior judges should be selected by provincial level courts and should start their careers in basic level courts. And then, gradually they'll be promoted to higher level courts based on their ability. This is a significant reform because it's so different from the current system, and the system that exists now is basically the work unit, model, the Danwei model. So the way you become a senior judge at a high-level court is you start out as a junior judge at a high-level court, and then, presumably through graduating from an elite law school with good grades, and then, you work your way up. But there's not a good system in place now for, identifying promising judges at lower levels and then promoting them to different courts at higher levels. But at the same time, the decision endorses the desirability of having senior and experienced people from outside the judiciary move laterally into it, much as experienced lawyers, say in the United States, cap off their career with a federal judgeship. So, there's a lot to be said for this. That would be terrific to have experienced people in the Chinese judiciary, but it's hard to see how this is going to square with the idea that the basic career path should be to start off at the bottom and work your way up to the top, because if you're an experienced lawyer, you're a partner at a big Beijing firm, you're not going to want to start out as a junior judge off in Qinghai province. There's a few reforms that have been touted as designed to address the problem of local protectionism, but I don't think they actually do. And these are two. The first one is this idea of circuit tribunals of the Supreme Court, which have been set up, as Min-Shin said, in Shenzhen and Shenyang. The thing is, though, they're called circuit tribunals somehow, but this is, if you interpret that in the American sense, it's extremely misleading because they aren't an appeals branch that's between the Supreme People's Court and the Provincial People's Court. They were a branch of the Supreme People's Court. They have the same identical jurisdiction. So a decision of one of these tribunals is a decision of the Supreme People's Court. It can't be appealed to the Supreme People's Court. One suspicion is that they're just designed to divert petitioners away from Beijing. If you want to petition the Supreme People's Court now, if Shenzhen is closer, you can petition the Supreme People's Court, right there in Shenzhen, or right up there in Shenyang, and you don't have to go to Beijing and cause a big fuss that's going to get the central leadership upset. But the important thing is their jurisdiction is not different at all in any respect from the jurisdiction of the Supreme People's Court. Then we have this other different proposal to establish what will actually be cross-jurisdictional courts. That is something above the provincial level. They will cover several provinces, and yet below the level of the Supreme People's Court. If China is going to do that, though, then you need legislative changes and possibly even constitutional changes. And so I was not aware that, Minxin mentions that courts have actually been set up now in Shanghai. If they are, and if they're actually functioning, then they're doing it without any legal basis, because there needs to be a revision in the court organization law and also perhaps in the Constitution to make that possible. And so to the best of my knowledge, legally speaking anyways, that still remains a proposed reform and hasn't really been implemented yet. There's an important reform. I'm going to call it relatively minor, but it's still important, and that is to the case docketing system. So, any system needs a kind of a gatekeeping. Any system of law needs a kind of gatekeeping function to try to weed out cases that are frivolous, non-meritorious, before you spend a lot of resources, judicial time, figuring out that they're frivolous and non-meritorious. And China has traditionally done this through what's called the case acceptance system, or case docketing, li'an. But that has been abused by courts who don't want to handle sensitive cases in which no matter how they rule, somebody's going to be upset and demonstrating outside the courthouse, and so very often they simply won't accept the case, even though it clearly falls within their jurisdiction. And so there have been attempts to reform this, and what the fourth plenum proposed was basically a case registration system where the court doesn't perform this kind of substantive review of the merits. You just bring your papers, and as long as all your T's are crossed and I's are dotted, the court will accept the case. So this will solve the problem of abuse of the case docketing system by courts, but it won't solve the problem of gatekeeping at all. And so my prediction is that the system cannot work as it is proposed because there's no way to weed out frivolous and non-meritorious suits, which of course occur in China just like they occur anywhere else. So something will have to change. Finally, I want to get to you may know the famous Sherlock Holmes story where he mentions, the curious incidents of the dog in the night, and Watson says, "What dog in the night?" And Holmes says, "Exactly, the dog did not bark." And there's a few dogs that did not bark in the fourth plenum decision that I want to talk about. And the first is a third plenum reform, a proposed reform to the system of court appointments and funding. And in the third plenum, this idea was that court appointments and funding would go up to the provincial level, in particular funding. And there wasn't anything said about that in the fourth plenum document. This reform is popular among legal academics, not so popular among judges, especially in the richer cities, because if you're in a place like Jiangsu, in the richer cities, you're getting paid a lot, and if in the poorer places, you're not getting paid very much. And judges are afraid that if the system of court finances is centralized up to the provincial level, that will have the effect of leveling down for them. Two more things I want to mention. These reforms are basically about courts, and so to the extent that the Chinese government system of governance doesn't involve courts, and that's about 95% of what it doesn't really bring much change to the way the Chinese government does things. And a very good example, which has already been talked about a couple of times today, is the response of the authorities to the stock market drop, which was the CSRC and the police began investigating so-called malicious short selling. This concept is completely made up. It does not exist in Chinese law. The CSRC and the police just made it up for these purposes, and a court is never going to be involved in this question of what counts as malicious short selling. And so this is, I think, similar to the way Chinese administration works in many cases, that people do what they feel they need to do to address the current needs, and nobody's really worrying about, nobody's there saying, well, wait a minute, malicious short selling does not exist anywhere in the Chinese legal system. What does it mean? The second thing, and this is, I think, a pretty major dog that didn't bark, is, and this is a complicated issue, the issue of local discretion in the administration of law. As Minxin pointed out, laws are formulated at the central level, but they're implemented at the local level. And so those who are formulating laws don't have experience in implementation and don't really know what the problems of implementation are. Those who implement them can't formulate the laws. And so the laws at the central level must necessarily be vague, and there's got to be a lot of discretion at the local level. The result of this is that they don't operate in a law-like way. And let me take tax for an example. In China, tax officials at the local level, and that's where almost all of them are, they have a portfolio of taxpayers that they're responsible for. They don't have subject matter responsibility. They have a portfolio of taxpayers, and it's their job to collect the taxes from their portfolio of taxpayers. So with that kind of system, it's impossible for the system, in a sense, the tax bureaucracy, to develop expertise in particular issues in tax law, accelerated depreciation deductions for certain types of capital investments, things like that. It is also impossible for a tax bar to develop that has experience and specialized knowledge in particular issues of tax law. And what that means then, is that China is unable to do kind of tax law, this is also true for securities law, in the way that, for example, the United States can do it, in which the government can actually outsource compliance advice to a private bar, paid for by the private sector. If you want to make a securities filing in the US, if you want to pay your taxes, you don't keep calling up the SEC or the IRS to ask for advice. You go to your lawyers, and your lawyers can give you reliable advice because the system operates in a law-like manner. In China, this can't happen the way the system currently works, because local officials have so much discretion. And that very fundamental aspect of the way law operates in China, there was no change in that proposed at the fourth plenum. So I'll stop there. Thank you.